I just wondered if we could tap your view right now, your experience on the significance of this moment. It gets bogged down in a lot of details and a lot of noise here involving multiple trials and many counts. The fact of the matter is the first criminal trial of a former president is now about to begin.
That's exactly right. The headline should be a former president of the United States is going to stand trial for business fraud. That's a serious headline. And, you know, it's a serious case factually. The way he paid Stormy Daniels and then lied about it on his books by repaying Michael Cohen, saying it was legal fees, there's no real defense to it factually. There is, however, a defense to it legally, whether or not the statutes that are used to charge him are appropriate in this case. And so there's going to be a big legal fight. But if they ever get down to just the facts of the case, I think he's got a hard time winning it.
Yeah, it's worth keeping in mind that he's charged with 34 felony counts here of falsifying business records, and what typically may be a misdemeanor has been escalated to a felony because Alvin Bragg argues it was done to subvert federal election law. So that's essentially what we're dealing with here. The question is whether or not we firmly, for sure, will be dealing with this beginning April 15th. Obviously, that is when the judge ruled today that jury selection will begin. But Donald Trump was talking about wanting to appeal. Do you see any real way in which this could get delayed even further, keeping in mind this was all supposed to start today of all days?
Yeah, I don't think there's another basis for delay. The judge has ruled on the pretrial motions. They determined that it wasn't selective prosecution and that there wasn't prosecutorial misconduct and that the case has been docketed and ready to go for a while. And so there is no appeal to take to delay this. And the judge is hell-bent on starting this thing. So, I mean, barring lightning striking, I think we're going to be picking a jury on April 15.
There you have it. As we wait to see if Donald Trump can pay this new lower bond in the civil case against him in New York, what was more than $450 million. Michael's now $175 million. This appeals court brought it down by more than 2/3. Was that the right thing to do?
I think so. I don't like the whole bail system, whether it's on the criminal justice side, where poor people are held pending trial because they can't make money bail, or in this case, where you have a $400+ million verdict and he's asking to put up $175 million, plus they could take liens on property if they need to. I think this was the right decision. I don't like people losing their rights in the system, criminal or civil, because of money. I just think it's a bad look. So I'm happy for this outcome. What's interesting about this decision, too, besides the $175 million, is that all the other parts of the order, save for the monitor, are also stayed. That is, the Trump kids can be part of business dealings in New York. Weisselberg can be part of business dealings in New York. They can get loans. So it's really sort of a slap at the trial judge's determination about what is an appropriate penalty in this case. And I don't know if that's a portend of how the Court of Appeals will deal with this on the merits, but I don't think it was a great day for the trial judge.
Well, I'm glad you brought that up, Michael, because my question was essentially that it may not be a great day for the trial judge or for Letitia James, for that matter, who argued that he should be posting this full amount because of concern that he ultimately would not, because this appeals process still has to play out. Does this change anything in your mind about the likelihood of the outcome of that appeal maybe being different than we would have thought before today?
Well, it's a great question, and I don't know for sure that this is not an indication that the Court of Appeals feels that the penalty may be too harsh. It may be that the Court of Appeals says, look, on the facts of the case, they've proved their case and he is held liable. But on the penalty phase of it, it's just, you know, like Eighth Amendment stuff. It's like cruel and unusual and beyond what the crime calls for, and they lower the penalty. But either way, even if the court were to lower the penalty, an appellate court lower the penalty to $175 million, that's a significant penalty. And it's a finding that this man and his company engaged in systemic fraud. And there's no good news about that judgment.
If you're glad or find it to be appropriate, I should say, Michael, that this bond was cut significantly, do you also think it would be inappropriate for Letitia James to begin seizing properties if he cannot pay this dollar figure?
properties are really tricky. I don't believe that Trump owns any of these properties outright. It's not like seizing our car or even our family home if we own it without a mortgage at this point. Yeah. He's got a lot of business partners and probably REITs and other mechanisms by which these are held. So it's not a very easy process that has a lot of implications for a lot of others of his partners. So if she were to start proceedings, I would start with cash and all of his liquid assets. And I think I'd leave the property until the last stage of any sort of judgment collection after a court of appeals ruled finally that he has to pay that amount of money. I just don't like divesting people of their interests in fire sale ways before there's a very final judgment from a court of appeals saying the end is here.
I'm just looking at my calendar here, Michael, trying to do some math. He has now 10 days to obviously make this bond. That would get us to Thursday, April 4th. Then 11 days after that is April 15th when the criminal trial would begin. And then just 10 days after the criminal trial starting is argument day for the Supreme Court. They'll be hearing arguments related to his immunity case, the issue of whether or not he is immune from prosecution as a former president in Jack Smith's 2020 election interference. How far from that argument date do you expect we'll actually get a ruling from the court for that matter? Because that would allow Jack Smith potentially to move forward with his trial once the New York trial wraps up. I realize I just said a lot there, but basically, When do we get a SCOTUS ruling?
Well, it's a great question, too. You got great questions today. In Bush versus Gore, there was a decision in 3 days. In United States versus Nixon, it was in a matter of weeks. And so the court has the capacity to rule in a 3-day, multiple week period. If they slow walk it and they wait till the end of the term, that'll be the end of June. The judges said if this is, a case that can now go forward because they found no immunity, parties will have 30 days to prepare. So let's say you take an end of June decision, a 30-day window to prepare. You could have a trial in early August, and this trial could last, August, September, October, and be done. So even if the court slow walks it, I think there's still time to try this case before the November election. And actually, of course, it's not the November election that even matters. They could try this case after the November election, whether he wins or loses. It's really January 6th that is the determination day of, whether he becomes president or not.